So good afternoon, everyone. My name is Tamara El-Shibib. I'm a senior patent and tech transfer consultant at Gowling WLG based in Dubai. Thank you for joining the fourth session of our webinar series on tech transfer and innovation. Before we start with panel introductions, I wanted to introduce the webinar series for those who are new to it. So the purpose of this webinar series is to discuss different topics within the umbrella of IP, tech transfer, and innovation. There are a lot of information gaps in this region when it comes to these topics. So the focus is to really share knowledge and best practices in these areas, but also to discuss the challenges and what we can learn from them. For today's discussion, we're focusing on IP strategies for managing software implemented innovations. We're going to focus on AI because there is a massive surge in AI-based innovations. And frankly, there is a lot to learn, especially if you don't come from an AI background like me. So having the right IP strategy is key for getting your technology to market and giving it the best chance of successfully getting to market as well. Before we dive into the topics, I wanted to say there is an opportunity for questions at the end of the session. So please type into the chat and we'll get to them in the last 5-10 minutes of the session. You'll also be prompted to complete a short survey at the end of the session. We'd appreciate any feedback you can give us on the session. If there are any particular topics you'd like us to cover in future, please also let us know. With that, I'm going to turn to the panel and ask them to introduce themselves. One of our panelists is actually having a bit of a tech issue joining the session, so that's Matt Hervey. We'll get him in as soon as we can. For now, left on my screen is Vivian. Vivian, could you give us a little introduction to yourself?
Hi, good morning, good afternoon, and good evening, everybody. My name is Vivian. I'm a Singapore patent attorney and heads the Patent and Industrial Design Group at Juris Asia LLC, which is the Singapore office and Southeast Asia arm of the global law firm Gowling WLG. I have a life science and clinical medicine research background, and my daily job involves drafting and prosecuting patent applications domestically and in foreign jurisdictions, as well as providing strategic advice on IP portfolio and risk management, as well as litigation support. And it's an honor for me to present here today as a panelist.
Thank you, Vivian. It's good to have you. Next on my screen is Sean. Sean, can you give us an intro?
Thank you. Good afternoon. I'm Sean Flanagan. I'm the Director of Technology Commercialization at King Abdullah University for Science and Technology, or KAUST, here in Saudi Arabia. Prior to that, I was in the same role in the National University of Singapore, where I also served the role as Director of Commercialization and IP for AI Singapore, a national level AI research initiative. I've been in the university tech transfer space for over 20 years, and I'm pleased to be sharing whatever insights I have today.
Thank you, Sean. We're pleased to have you. Fawaz, could you give us an introduction?
Good morning and good afternoon, good evening, everyone. My name is Fawaz Al-Qahtani. I'm Acting Director of Tech Transfer Office at Hamad bin Khalifa University, Qatar Foundation. I've been in the industry of in the tech transfer industry since 2017, and prior to this experience, I was a research scientist at Texas A&M for more than 8 years. I hold a PhD in electrical and computer engineering. Basically, my daily activities that I do is just only to oversee the IP activities from IP capture until the commercialization. So that's basically what we do. Thank you.
Thank you, Fawaz. So today's discussion is going to focus on these topics. We've got about an hour, so we'll try our best to cover all of them. This is sort of an informal discussion, so we'll sort of follow the flow of the discussion. But basically, we're going to discuss trends in R&D and IP for emerging tech with a focus on AI, processes for identifying and evaluating software and AI inventions. We're going to discuss IP protection considerations for software and AI innovations, and then patenting considerations for software and AI, because these are treated differently to traditional tech. We'll also cover data assets. So these can also be really valuable when you're dealing with AI. How can you protect your data assets? And then we'll briefly discuss the challenges in commercializing software and AI related inventions. There's a lot to talk about when it comes to the challenges. So I think we will need a separate session on that, but let's just dive straight in. When it comes to emerging high-tech areas, so they're broadly categorized as these 5. And there's a lot of IP development in these areas, particularly because a lot of these are sort of platform technologies and you can apply them across various industries. I think the fastest growing in terms of these top 5 is definitely AI and machine learning. And there's a lot of stats sort of backing that up, which we'll cover in a second. But before we do that, I want to turn to the panel. Sorry. Hi, Matt. Are you there?
Yeah, my camera's showing me upside down. Let me just see if it's. I may have to do it without camera.
No worries. It's also showing you my name as well. But
Clever. Okay.
I'm just going to turn back to introduce you. So hi, everyone. Just to get Matt up to speed, Matt Hervey is a partner with Gowling and the head of our AI team based in the UK. And Matt, we're just going through the topics for today, and then I'll loop you back in.
Fantastic.
So turning to the panelists, I want to start first by asking Sean and Fawaz in terms of R&D, what are the trends that you're seeing when it comes to these areas? So Sean, do you want to take that first?
Sure, thanks very much. I think definitely here at KAUST, we are seeing a tremendous interest in approaching almost all levels of research, whether it's desert agriculture or biology or any of our traditional areas of research are seeing an ever increasing interest in developing AI or ML solutions to go alongside of those technologies. We're seeing an increased utilization of the data that's been collected through the physical manifestation of research, often sensors or devices for collecting information, and how we can use AI and ML in order to process those mountains of data in order to determine what the patterns are. So what we're seeing is there's definitely an uptick in the amount of software-enabled technologies or software-enabled hardware. We're definitely seeing a lot of standalone software, especially in the AI Institute. And we are seeing an ever-increasing interest in adapting new solutions in AI ML for historical approaches to whether it's drug discovery or any other analysis that might have otherwise taken a lot of significant repetitive research.
And Fawaz, would you say that's the same for QF as well?
Yeah, it's exactly. Yeah, I think right now, for example, last year we have more than 150 invention disclosures. So by looking like into the into the whole spectrum of IPs, we identified more than 60 to 65% of the whole activities. They are in the domain of AI. Some of the AI that like in the health, lots of even material science right now, I see lots of activities they are using AI, which is, I mean, this is for the first time I see it this year, and I see lots of involvement and lots of engagement, and I see even the industry, they are highly they want to explore more about getting AI into the domain of material science. Even if you look to the AI last year is completely different from this year. I mean, we've been discussing within the tech transfer and within the research institute for the last 3 weeks about some of the areas that we've been doing research for the last 7 or 8 years. After the introduction of large language models like ChatGPT and the multimodal the GPT-4. So right now we are going through different workshops, talking to people, to the scientists, and we are trying to explore, are these, shall we do exactly the same as we do before, or things are changing? So I think the industry is moving so fast. But definitely AI, it's getting into all the discipline, it's getting into all the portfolios. You know, we have bio, we have health, we have bio, we have energy and environment, and we have computing. And I can see lots of the AI and machine learning, they are getting into these different disciplines, and I believe things will be changing in the future in terms of AI involvement in these areas.
Yep, and I think the numbers here completely correlate with what you're saying. So there's also been a bit of an AI patent boom over the last 10 years. And a lot of that is sort of focused on machine learning as well. So here's just to give the audience a little bit of background into what's going on with IP, with AI in the IP world. There's been sort of over 340,000 applications according to WIPO that relate to AI, and half of those have been sort of filed in the last 10 years. When it comes to patent applicants, majority of them are based in Japan, US, China, and the top 5 AI patent filers, as you could guess, it's sort of the big tech giants. In terms of university research, a lot of that is coming from China. So they're leading the way in terms of scientific publications and leading the way in terms of university applicants as well when it comes to AI. Generally speaking, and before I turn to Vivian and Matt, my understanding is when you're talking about AI innovations, these can be grouped into sort of 3 areas. So it's either techniques used in AI, like machine learning, or it's functional applications of AI, so natural language processing or computer vision. And then there is the application of AI in different areas. So like I said, 1/3 of patent applications that are filed relate to machine learning. I'm going to turn to you, Matt. Is that sort of the trend you're seeing as well when it comes to AI? Is it machine learning that's sort of taking over in terms of IP activity?
Yeah, 100%. So AI has been a research area since the 1940s. And for the majority of that time, people were pursuing what's now known as an expert system, whereas humans trying to code a machine to replicate a human task. But really, since about 2010, the artificial neural network as a form of machine learning really re-established the concept that machines can teach themselves using training data, how to automate certain tasks. And among those, the 2 you've pulled out, the natural language processing, computer vision, have been incredibly significant commercially because it allows you to automate a huge range of human tasks, everything from autonomous vehicles to voice assistants. And it's really that technology that has made AI appear on the industrial strategy of almost every major economy. And the only thing I would say about IP trends in general is you're absolutely right, vast increases in IP filings. It's certainly doubled in the US in about 10 years. I read this morning it's 6% of all filings in India relate to AI at the moment. I think the other big trend is trade secrets, a huge increase there. So litigation in the States is up 14% annually over the last decade. So very significant. And then the other area that's become super hot now is generative AI. That's AI to create images and text and code and just about anything you can think of. And that is not only becoming significant, so OpenAI garnered 100 million users and claimed to be the fastest growing technology in terms of adoption ever.
Yep.
But it's also sparked litigation. So in the US and the UK, we're seeing the first litigation about generative AI in terms of copyright infringement.
I'm going to come back to the point about trade secrets because I think that's really interesting that there's a rise in trade secret litigation at the same time as we're having this AI sort of boom as well. Before I do, Vivian, I'm going to come to you. Are you seeing sort of similar trends, I guess?
Yeah, definitely. Definitely. We definitely see very rapid development in this area, especially covering metaverse, NFTs, blockchain technologies. And I would like to mention something interesting that even in the trademark field, we have seen a surge of Web3 trademark filings recent years, as many companies would file applications for marks for use in the virtual environments and in relation to NFTs. So in Singapore, there's an example concerning the company Nike. So back in the 1990s, Nike obtained a Singapore trademark registration for that famous swoosh logo for footwear, clothing, and headgear. But recently, they filed and obtained acceptance for another Singapore trademark application for the same logo, but it covers various virtual goods and services. So I think this shows that they really expect more local users of the metaverse, which is kind of promising sign for other business to start mapping out the plans for the metaverse presence. Then in the patent field, I would say that increasingly the life science companies are also exploring the potential of AI. So to name a few applications of AI in life science, AI has been used to assist drug discovery by swiftly shortlisting potential drug candidates. It has also been used to diagnose disease using medical images. And it has also been used for AI-driven robotic surgeons, intelligent drug applicators, or even intelligent logistics, such as predicting demand peaks and adapting the supply chain accordingly. So I would say that in Singapore generally, especially in life science area, and I assume in other areas, AI is a hot topic and everybody's trying to grasp that benefits from it.
Yep, I think when it comes to the UAE, it's quite similar as well. A lot of the work that we're seeing is also AI related across different industries as well. Health, ag tech, basically across the industries that are relevant in the region as well. So definitely mirroring that trend. When it comes to managing sort of AI inventions, for me personally, I see a lot of developers working on solutions using AI, but sort of what is the first step in terms of evaluating whether you've got an AI solution versus sort of an AI innovation? I'm going to turn to Sean and sort of ask you, what are the processes that you have internally to evaluate when you've got sort of a new AI or software related invention?
Well, the first thing we had to do was develop an entire software disclosure system. We saw that with the increasing numbers of non-patent related discoveries that were taking place, we weren't really prepared for handling that kind of influx. And while it collects a lot of the same data, it critically asks some important questions about the origination of the concept and what tools were used in order to develop the solution. I agree. We are seeing applications more than entirely new algorithms. We're seeing approaches to using and understanding and adaptation, and that creates a lot of opportunity for contamination of the original work by outside source, whether it's shared code or code that's taken from, or data that's taken from a source that is not proprietary to the parties that are disclosing it. So our approach is to gather as much information as we possibly can about the software that's being disclosed, understand what the pathway through to the anticipated market, because they're solutions driven, we're seeing that the anticipation is that it's very fast to market. So we don't have the traditional timelines that we can with patents in order to evaluate which way we're going to go, because often we are looking at, do we have the right material in order to move through to venture funding to get through that first mover advantage, and a patent often is not going to be the right pathway for these. So I agree. We're taking trade secret a lot more seriously, which is kind of the antithesis of a university. You know, we're in the business of not keeping secrets. We're about publication, but increasingly, as some of these tools, especially for student-led startups, are coming out, we're having to find ways in order to make it available. So, I mean, I think it's about collecting the most information you have about how the solution was derived, and then taking a critical evaluation as to what they intend to do with it, so that it can survive whatever diligence is going to come thereafter.
Yeah, I think what you mentioned as well about sort of figuring out the origins as well is really key. We've seen a few cases where, for example, I mean, it's very common to use open source software because it helps you sort of save development time and cost. But sometimes some of this open source software is under or has restrictions related to patent ownership or commercial use, especially if it's like a subscription-based software that you're using. So I think it's really key that before you invest time in trying to patent or commercialize something, you kind of understand where it's come from and what you can do with any derivative work. Fawaz, I'm going to turn to you quickly. Do you have a similar process in place as well when it comes to
I mean, after capturing the new, we have the new invention disclosure. We try to look at the technology itself. Sometimes we gather more information, and for me and the office, we have this inventor meetings. We sit with them, we discuss with them. So what I realized, there are two types of AI. When I discuss with the guys who are coming from the AI background, it's different from the solution that's coming from a different, like from health. They are using AI, and energy and environment, they are coming, or telecom, they are coming from AI. And I can see there are lots of activities they do. It's off the shelf type of techniques. And usually we try to discuss with them, hey guys, this is not patentable subject matter. And but in the meanwhile, they are providing great solutions. So we tell them, hey guys, since it has a great commercial value, then I think it's better off to have it as a trade secret. And then from there, we can further develop the technology to take it to the market. And then for the AI solution, for example, that's coming from the computing research institutes, machine learning is just only one block of the whole end-to-end solution. So, you have pre-processing, you have machine learning, and you have, even going to the cloud, coming back. There are lots of ingredients. We can tell from there this has a potential to be patented or no. And honestly, we are commercialization driven. And since we are commercialization driven, we need to make sure, like anything that will be disclosed later on through when we have patent granted, or we have patent application, this type of algorithm, it's very hard to police. That's when we miss, the value of the. So as I said, the process just only we meet, we gather lots of information, and then we decide what's the best scenario based on the future activities, if this one will be commercialized or not.
That makes sense. Okay, and turning to Matt next, in terms of protecting AI inventions, what would you say are the elements that can be protected?
Well, potentially everything, depending on which strategy you approach. So obviously the raw data or the training data or the extracted data, it might be in the form of a copyright work. So it could be you're using images or academic articles, and they have copyright. And there the real issue is whether you are subject to text and data mining exceptions, which allow people to mine your copyright works without a license. And that's definitely an issue which is going before the courts in the US and the UK at the moment. And it's also an area where various governments are looking whether they need to change the law in those respects. If it's not a copyright work, for data, you're very much looking at trade secrets. And we can talk about that in more detail later if you wish. Then for code, if it's human written, it's protected by copyright. So if you have a human who's written the learning algorithm, the framework by which the machine is going to learn, that will be copyright. But copyright is a limited protection. So it protects the expression, how you've written the code, the choice of phrasing, as it were, albeit it's code, not the underlying principles. So it doesn't create any monopoly to the methods or the ideas. And indeed, in the EU and the UK, you're not allowed to prevent lawful users of your software from reverse engineering. A term to that effect would be void. So where you're looking is, to the extent you aren't protecting what you want through copyright, you either need to fall under patent law protection. And obviously patent law excludes computer programs as such, but does allow some software essentially to be patented where it improves the way an AI works, or where it has some sort of real world application outside of the AI. Then you have the stuff generated by the machine itself, either the model or the algorithm it uses to make its predictions, or the outputs themselves. And generally speaking, in most jurisdictions, stuff generated by an AI isn't protectable as a form of intellectual property. There are some exceptions for copyright. The UK is an exception there, for example, and also designs if they're outputs. So we're falling back there generally where IP doesn't reach on trade secrets and practical measures and contractual measures to keep your proprietary techniques and innovations to yourself.
Are you seeing sort of clients in for trade secret protection more than patents when it comes to AI? Only because I know with AI, there's a lot of sort of rapid advancements in the area, and there's ways to sort of invent around, and you need to be able to detect if somebody is infringing on your patent for it to be worth patenting.
Yeah.
Okay.
So it's hard to measure, obviously. The only public data is on applications. There's no public data on trade secret adoption, albeit that enforcement is clearly rising, particularly in the US, which suggests people are taking trade secrets more seriously. But what I would say anecdotally is that clients are increasingly asking us to help with their procedures and documentation and the like for trade secrets, particularly where their assets relate to AI.
That makes sense. So we'll touch briefly on patents and patenting AI inventions. So I think the key message here is, yes, you can patent AI-related inventions. Usually you have to sort of frame the invention in terms of a problem and a solution, and provided, you have to look at what is the AI being used for. Is it a technical purpose or a non-technical purpose? And if it's technical, is it an obvious use or not? So it has the same criteria, I would say, as patenting any technology. It has to be something that's new, something that's not obvious or inventive, and something that's technical. When it comes to patenting issues around AI, what are the main issues that we're seeing? I'm going to turn to you, Vivian, for this.
Yeah, so I would say that the first consideration is that not all the inventions are eligible for patent protection. So for instance, I think around most of the jurisdictions in the world, mathematical methods such as algorithms per se are not considered inventions. But if the patent application relates to application of, for example, a machine learning method to solve a specific problem in a manner that goes beyond that underlying mathematical method, then the application could be considered as an invention. So an example would be use a machine learning method in controlling the navigation of an autonomous vehicle. And so I would say that it is very important to highlight the important technical advantages and practical details when drafting patent, and this can increase the likelihood of success during the patent examination. And bear in mind that the AI tool can also be embodied in a physical form, such as in a medical device. So actually, I've looked at the some examples set by the EPO examination guidelines and some EP case laws. So, for example, a method of providing medical diagnosis by an automated system processing physiological measurements is considered a patentable subject matter. And using the method to identify irregular heartbeats or to predict the binding affinity of one ligand or molecule on one target protein is also considered patentable subject matter. So I think particular care should be taken when drafting patent application directed to an AI algorithm, as the patent application will be published and become part of the prior art. So if an inappropriately drafted patent application, if it's rejected by using the AI algorithm described in the patent application.
I think when it comes to AI as well, we in the UAE usually look to what's happening with the EPO and the US as well. We don't have any specific guidelines, I think, issued in the region when it comes to dealing with AI-related inventions, but we do know that here in the patent offices, they do look favorably towards applications that have successfully been prosecuted in one of the other big patent offices. So that usually helps speed up examination regionally as well. When it comes to inventorship and ownership, Matt, what is the main issue when it comes to AI inventions? I think we all know about Davos, the case.
Yeah, and I think Robert Gehan is on the call actually, who's just been in the Supreme Court on that very point. So Davos, we wait to see a couple of months from the Supreme Court here to see if our jurisdiction will allow invention by AI. But certainly all the substantive hearings elsewhere have to date failed. But I think that the big challenges are the exceptions, which we talked about. So things like mathematical methods and the like, computer programs as such. There is also lots of publicly searchable prior art in this field in AI. There's, very, very, well, Archive and other sites like that contain a huge amount of prior art. You've also mentioned the issues with enforcement. So a lot of the patents granted are quite narrow, and so workarounds are easy. It's hard to detect infringement because AI is, as legend has it, the black box. You can't tell exactly what's going on inside it often. And it's often deployed in the cloud outside the jurisdiction. So you have to take a lot of care about how it's drafted to make sure you can make a claim within a single jurisdiction. And then the other thing to consider is sufficiency. So is the skilled person able to work the invention? And often valuable AI is based on proprietary data. So you may need to frame your invention in terms of publicly available data to show that the invention can be worked by others. But again, I would say, because of all of these issues, do also consider trade secrets.
Yep, that's a topic that we're going to come on to very shortly. Before I do, I just wanted to quickly sort of discuss the patent filing strategies that you can sort of take advantage of if you're dealing with an AI-related application. Because there's developments that are happening so quickly in this space, instead of, you might want to speed up examination and prosecution. And so I know that some of the patent offices have that as an option. I was going to turn to you, Vivian. Are there any particular benefits for applicants to file sort of through the Singaporean Patent Office?
Definitely. So the Intellectual Property Office of Singapore, IPOS, it has a range of programs that allow AI innovators to accelerate patent applications. So locally, we have the Singapore IP Fast Track program, which allows the patent applications in all fields of technology, including AI, that are first filed in Singapore to be granted in as fast as 6 months. So the applicants can also use their Singapore patent application to expedite the prosecution in more than 30 other jurisdictions through IPOS network of work sharing agreements. So for example, AI inventions are eligible for something called SBAC acceleration for Industry 4.0 in infrastructure and manufacturing initiative. So under this initiative, the patent officers in 8 other ASEAN countries, they are able to rely on the Singapore Search and Examination Result Report, and they are committed to respond within 6 months, whether those applications could be accelerated there or not. And in addition, IPOS also established the bilateral and global patent prosecution highways. Actually, it covers more than 20 other jurisdictions, including key markets such as US, EP, China, Japan, Korea. So yeah, there are loads of accelerating routes in Singapore.
It's nice to see the patent offices sort of trying to keep up with the trend as well, and sort of offer applicants, I guess, ways to help them stay on top and make sure that they're not sort of delayed in the process as well, because it's so important in this area. I'm going to turn to data now, because I think this is really important and probably not discussed enough. When it comes to the training data, so we're sticking with machine learning here when it comes to AI. Typically, when you're patenting, you don't necessarily have to disclose the training data itself, but you kind of need to describe the type of data and how it will be used. So I think it's really important that you know, before you go ahead and patent, have a good sort of understanding, you know, where are you getting your data from? What do you plan to do with your data? Are you okay with, do you prefer to keep it sort of secret, or are you okay with this becoming published? And another thing to think about is the model generating data that is valuable itself. So it's data, the IP that's being generated as well. When it comes to protecting data assets, Matt, I'm going to turn to you. Sort of what are the different tools that you can use to do that?
So I'll just say, to preface this, I don't know that the answer on sufficiency is settled and whether you do need to disclose your training data. I think guidance so far from patent offices has been somewhat bland, that the normal rules of sufficiency will apply. I've certainly heard patent professionals suggesting that they might need to literally upload all of the data or supply it in the way that I think genome data and other have been used in the past in patent applications. So that's to be seen, and it could lead to swaths of invalidity if a court decides sufficiency is tougher than we thought. But in terms of protecting your data per se, as I said earlier, it may be copyright, and you may be able to deal with that way, subject to text and data mining exceptions. But certainly information per se is excluded from IP on policy grounds, and that's in all the international treaties. So you really will need to protect it as a secret. And that means a mixture of practical measures, so keeping firewalls and access logs and the like, contractual measures, so NDAs and the like with collaborators and employees, and then, if necessary, seeking remedies under trade secrets law, which are well harmonized under TRIPS, and we all largely have a common definition these days. So it's a commercial secret that's valuable because it's secret, but all important that you've taken reasonable steps to keep secret. So the all important step, I think, for companies, as well as keeping it actually secret and avoiding a problem, is to be able to prove that they've taken reasonable steps. So I think a lot of that comes down to making sure you have logs of what policies apply to your core trade secrets, who's responsible for it, who clears publications to make sure it's not leaked accidentally, and to collate that evidence of the measures under each policy that applies, so that you can quickly get an interim injunction in the case of some sort of breach.
Yep, I think it's key that you sort of show that you're taking reasonable steps as well, just based on the recent litigation that I've heard about as well. A lot of times the courts are looking to what are sort of the extra protective measures that you're putting in place. So
they just have to be appropriate to the nature of the secret as well. So, you know, there's no point in having a firewall if it can be reverse engineered from a physical object, for example. A rather cheeky defense that was attempted in the States was, because the defendant had been able to steal the secret, they can't have taken reasonable measures. But that one was not enough to strike out the case.
I'm going to turn to you, Sean. Do you have any sort of mechanisms in place at the moment for capturing data and
No,
managing?
it's funny. Yeah, we have had to, again, go back and innovate our processes in order to deal with the innovations that are taking place, because it takes me back to the days before the AIA and when I used to give lectures to new faculty or students about keeping good lab notes and everything. And now we thought we were past that, but now because of data, we're having to again make sure that we've got controlled access. All of those good practices are coming back in the university setting in case we have to use a trade secret route in order to protect the data. I mean, primarily our approach is to look at data as part of the license that comes into a collaboration, whether it's as part of the background IP, but also as the confidential information within the agreement, to make sure that we've tightened up our agreement so that when we're giving license to our background IP, we're specifically giving license to our data. Because increasingly, because the universities around the world have historically collected a lot of data that can be repurposed for commercial applications nowadays, and we're finding that there is a market for certain of the data that we've collected as a result of the basic research. So our normal approach is through license and contractual controls. We're limiting access by not necessarily publishing all of the data when possible as part of the academic pursuit, but to the extent that the information has to be published as part of the academic publication as opposed to a patent application, then we're kind of out the door after that. So often there's more data that we can monetize, there's more data that we can provide access to, but increasingly data is a larger portion of the discussions, when it used to be just included in the definition of intellectual property incorrectly.
Do you see that sort of through your licensing transactions, that data is a core part of the transaction when you're licensing your technology? Absolutely, especially if we're licensing a model, an AI model for any particular purpose. The training data, there's an expectation that the training data is going to be included with the delivery of the model, and we're having to educate, say, look, you can have access to the model, but the price point changes if you want to have access to the training data while you are building your own repository of utilization data. So it's causing some, I would suggest, unique conversations. Yep, that's interesting. And Fawaz, are you seeing the same thing as well when it comes to data value, when it comes to
like for us, when it comes to the genome data, when it comes to the images, medical images, this one it's mostly confidential. We don't we usually, like our process, we let the research center to disclose it to us, so we keep it in our record in our database. But definitely we don't we keep them confidential. We don't share them with anyone else. So when it comes to the academic, I don't remember if we had any commercialization activities by sharing our data with what we do research collaboration with different institutions, either regionally or internationally. What we do, for example, we share with them our data, they send us the model in return. So we give them the data, they give us a model, or sometimes we get data from different university worldwide, and we give them the model. This is the type of things. And sometimes researchers or faculties, they need to publish their own data. It's become it's become one of the recognition to what they are doing. So depends on the data. So the data, if it's just only normal gathering data of food images, or for example, so we let them just take it and publish it. At the same time, we give it to, we have Qatar National Library, which all the local here in Qatar, local and president of Qatar, they have access to Qatar National Library. So all the data we have, which is, I'm talking about the data, not confidential one. So we give it, we share it with the QNL, and we put it in the database so anyone can access through Qatar National Research Library to this data. So this is basically what we do. This is our activity, and honestly, it's not too much, but the Genome Project is a huge data that's been for a while, for the last 9 and 10 years. We gather lots of data, but still it's kept confidential so far.
Yeah, that's a huge project, and I remember that from my time when I was in Qatar as well.
It has been utilized a lot, lots of great research outcomes out of it, and we are collaborating with some of the hospital in Saudi and some of the hospital in Europe, so it's coming along. It's good.
Yeah.
So,
and I think it's really interesting as well when you have sort of open data that different parties can use to build solutions off of. I think that helps to accelerate innovation as well. So that's a great strategy too. Vivian, I know you've worked with a university before, and I know that there are certain measures that they can take or put in place when it comes to protecting and managing trade secrets. Are there any sort of examples of things that they've done?
I would say that non-disclosure agreements are essential in the early stage of disclosure, especially if you would like to seek third-party collaborations.
Yeah.
So always make sure that these documents are in place. Then you also includes, very importantly, to train the employees so that they understand their obligations to safeguard the confidential information. Because in a lot of US trade secret lawsuits, the defendants they will claim that they are not aware that those information are actually confidential information, and they have obligation. So I think it is very important to train the employees early on, and try to limit access to the smallest number of people possible who need to see that information. And other measures could possibly include having a good cybersecurity policy within whether it's a university or other company. And it's also important to have a robust onboarding and offboarding procedures when the employee joins the organization or leaves. Sometimes I see that when they exit that company, they need to sign a memorandum saying that they are aware that certain information that they had access to during the employment are actually trade secrets, and they are aware that they have a special obligation to keep it secret.
Mm-hmm.
Yeah.
Yeah, I think maybe a lot of entities are sort of coming on board with creating their own confidential information policies or policies around trade secrets. But I think that's still an area that's picking up slowly, and probably correlates to, you know, the rise in trade secret litigation and the AI boom as well, when you're dealing with innovations that you wouldn't necessarily patent and you might decide to keep as trade secrets. So for the last...
Laura, can I add actually that one thing
Yeah.
we haven't covered, reverse engineering of models. So Sean was saying, you know, they would license the model, but you wouldn't give them the training data. For some models, they're quite vulnerable to reverse engineering. You put data, test it with data, get the outputs, and you essentially reverse engineer the model or even elements of training data. So you need to think about practical measures like APIs, putting it in the cloud, limiting what people can put into it.
That's an important point. Thank you.
Yeah, our mode is actually just on that, just as a suggestion, as people might want to think about it, is we've taken a subscription approach, you know, adopting some approach from other forms of copyright media exchange, and saying that subscriptions are a way you can have access to the data. And as long as you maintain your subscription, then you can utilize the data with the model.
Mm-hmm. That's a good way of sort of controlling the data as well.
And can be used through API, not to share the data, but you can access to the data through the APIs, and this work as well.
Mm-hmm.
That's
a good point. When it comes to commercializing AI-related inventions, I'm going to turn to you, Fawaz, because I know you deal a lot with that. What are sort of the main challenges that are coming up for you?
Okay, I mean, we've been very active for the last few years, and right now I think we have up to 9 startups that coming out. You know, I look at the commercialization. It's end to end. You know, it's from the early capture until go to the market. You know, so sometimes we had issue. I mean, the commercialization bottleneck, like in the middle when we want to de-risk the technology. Sometimes we need partner, like to take it, for example, to work with them closely until we have, you know, the right product or the right solution to be going to the market. And sometimes this one doesn't work a lot, and sometimes we find the right one, but you know, the agreement or the terms that we discuss, we did not come to like an agreement, so we had sometimes to stop. But one of the scenarios, for example, we have a very well developed solution. You know, the solution goes to the market, and then we have the issues when it comes to the team and how do they manage and how do they, you know, have more customers, and some of them they fail. I look at this one as we've been experiencing this one. So when any related type of startup that related to AI, you know, building a solution, it can be, you know, it's possible, but I think the thing that we need to be careful is just when we go to the market for AI, for solutions that related to AI, it's very challenging. You have, I mean, you know, the founder or the CEO of the startup, he need to be more engaged. You know, he need to, you know, aggressively getting into the market, getting more customers, because for example, we have this technology that we developed in 2019. It was the state of the art, but we had issue with the founder. He'd been, you know, going back and forth. He didn't have the right strategy to grasp the market share. And then I can see many technologies doing exactly what we do, and right now they are getting more share than what we do. So when it comes to the commercialization, it's not, there are lots of factors that you need to be careful. So you need to look at you know, how to further develop the technology. Sometimes when we reach to TRL 4 or 5, sometimes we try to find, you know, more funding to de-risk the technology. When we succeed in this portion to TR9 and we take the solution to the market, then we have, you know, the other, you know, stuff that, you know, it's like any business. So what I see, the solution, I look at the solution just only, it's 30 to 40% of the whole, you know, end to end, but definitely the 60% it's in the market, and how to lead the product and how to get more customer. This is the way more than the technology itself.
Yeah. So the solution is just basically one part of it, but there's so many other steps and things that have to happen before you can successfully take something to market. Sean, oh, sorry.
The solution is not, I can say it's not the big part of it.
Yeah.
I would say like 40% the solution it's worth, you know, but definitely the business outside, this is very crucial.
Yeah, the investment, the resources that it takes to take it forward. I agree. I think the solution is only like the first part, and it can take years to take something to market. But in this area, you have to be quick, which means you need to have resources at your disposal. Sean, is there anything you want to add on that?
No, it's just fast. You got to move fast, and getting to that first customer revenue and validating the assumptions. I mean, it kind of puts the lean startup model on its head, because you need to get out there as quickly as possible. But sometimes that means you're finding out what your product is while you're speaking to customers with what you have. So no, I agree completely with Fawaz. You got to be fast, and it's not about the tech until it comes to raising money. And often that's one of the fallbacks that somebody will say, okay, well, what's your IP provision? They say, well, we've got a trade secret, and that creates a pause in the conversation around raising money, which is, I think that's just a matter of educating the investors and making sure that they understand that there are different ways of protecting the opportunity.
Yeah, I think when it comes to commercialization, there's a lot more that we could cover. But this webinar is actually coming to a close in 2 minutes. I want to give some time quickly to a couple of questions that we've received. So the first question is, for the invention disclosure form, what do you find your minimum requirements on the invention details to be sufficient to favorably pass the IDF evaluation stage. So basically, when it comes to sufficiency of the invention disclosure form, sort of what is the minimum that you require from inventors to move forward? I mean, if I were to answer that, I would say it's very tricky to do a proper evaluation or analysis on an invention without fully understanding what it is that you're dealing with. But I'm going to turn to you, Sean, as well. Is there sort of a particular process that you follow for this?
I mean, it's part. I mean, we use the disclosure as a starting point, and then we have a dialogue. And through those dialogues, what we want to tease out is, do you know exactly everybody who was involved in the development of the solution that you have? For those people that were involved, have you confirmed what tools that they used? Have they, and have you articulated within the disclosure what available resources that might have been used? And then we drill down to find out what the truly novel components are. And I think we err on the side of caution or of generosity insofar as accepting what people come through. But they have to understand that, I mean, the questions that we ask are going to be, a cakewalk compared to what's going to be asked them if they try to raise money against a poorly conceived piece of software.
And actually, the next question is somewhat related. So it's basically how much development work do the inventors have to do before you consider something ready enough for you to take forward?
I mean, I guess it depends where it starts. I mean, if they come to us with a concept and they haven't done any of the coding, then we've got a lot of work to do. If they come to us with a near commercial grade piece of software, but they just need to work on the UI, then I mean, I guess we're almost at the market. I mean, it depends on the starting point, depends on where they want to get to. Often, the resources are limited, and what we can do is help by quickly bringing money into the equation so that they can overcome some of those challenges.
Yeah, I mean, I think the more development work there is, the more it comes back to what Fawaz was saying about de-risking. Right, so like it works, you've tested it out, and you can get more, I guess, investment or resources assigned or allocated to that particular invention because it's further along. So it's actually past 5 o'clock now, so I'm going to have to say goodbye and end this webinar. But I wanted to thank you all for participating in this. I think this was an excellent discussion. And I think we might need to do a follow-on session at some point as well. And to the audience, thank you for joining us today. If you have any follow-up questions, please feel free to email those to us directly, and I can make sure it gets to the panelists. And yeah, just want to end there and say, hope everyone has a good afternoon or evening. And thanks again.